Good morning, everybody, and welcome to our class number 6 of our 2025 Virtual HOA and Condo Academy. Today is Tuesday, June 17th, 2025, and our class topic today is going to be Master the Amendment Process and Effectively Work with Rental Properties. So hi, everybody. For those of you who I haven't met before, my name is Beth Mulcahy, and I'm going to be your presenter today. I'm going to give everybody a few seconds for attendees to enter the Zoom and to get settled here. Welcome to our class today. This is our June 2025 Virtual HOA Condo Academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. And we're so thankful that the neighborhood services departments from these respective cities want to provide free education to board members, homeowners, and managers about the ins and outs of how to run an effective community association, HOA, or condominium association. So for those of you who are just joining in one of our classes for the first time, I'd like to introduce myself. My name is Beth Mulcahy, and I am the founder and senior partner of the Mulcahy Law Firm in Phoenix, Arizona. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board, and I have for many years. Today's class, we're going to be discussing our 5-step plan for amending CC&Rs. This 5-step plan has been developed over the past 28 years, where our firm has been representing HOAs and condominiums. And we've come up with a process that is effective in getting those amendments passed. We're also going to be talking about implementing rental restrictions for community associations and why you may want to implement short-term rental restrictions or long-term rental restrictions and the process to do that. And then we're going to jump right into talking about how to effectively work with rental properties in your association. As always, we're going to address your questions at the end of this class. I will conclude the main presentation right at noon, and we will move right into the questions at that time. Due to the large volume of attendees, please note that there is one question per attendee. And if you're joining us on Zoom today, please be sure to submit your question in the Q&A box. And if you're joining us on Facebook, please type your questions in the comments section. Okay, we're going to start out here with a poll. On your screen, you're going to see a poll. And the first question is, in which city do you reside? And then the second question is going to be, let us know your current role with the association. So what we're going to do is we're going to have you fill out the poll. And while you're doing that, we're going to be talking a little bit about what's going on in our legislature right now. Let's give you a quick update. As you know, the Arizona legislature began their 2025 session on January 13th, 2025. And if you can believe it, it's still going strong as of June 17th this morning. Thus far, there's 4 bills that directly impact HOAs and condominiums that have been signed by our governor. And the process is it has to pass the Arizona State House and the Arizona State Senate, and then it gets sent to the legislature for their review. And then it gets sent to the governor for the governor to sign it once both chambers of the House and the Senate have passed the bills. So 4 bills this year so far. The Arizona legislature did take a long break in May as the budget talks took place behind the scenes. And then since May 7th, the Senate has only met once to consider bills on May 28th. And the House has only met twice on May 20th and June 4th. But as of today, the legislature is still in session, and they're actively working on finalizing the state's budget. The House has already passed its budget proposal, but the Senate is finalizing its own plan and has been negotiating with Governor Hobbs. The Senate budget is expected to be released and debated very soon, with legislative leaders hoping to approve it by this Wednesday, which would be tomorrow. I don't know if that's going to happen, but we'll have to wait and see, and we'll keep you posted if anything happens on this. There is a short list of bills the House seems to be scrambling to push through, and there's really no bill activity in the Senate, probably because they've got their hands full with the budget. But there's no consideration or pushing to get, bills that pertain to HOAs and condominiums. across the finish line. So it kind of looks like there might be a surprise, but very unlikely. It looks like we're probably only going to get these 4 bills that were passed this year and signed by the governor. The legislature is scheduled to adjourn on June 30th. And, we're closely watching the next really kind of game time. It's the last 2 weeks of June right now, and we'll just have to see what happens. And I think kind of the last minute push here now in the legislature is to get that budget passed. And as soon as that happens, maybe they'll have one last scramble day of bills being introduced and passed, and then it'll be over. Then it will be the legislative session will end, and then we'll have 90 days after the legislative session ends, all of the bills that pass this year pertaining to HOAs and condominiums will become the law. So, realistically, we're kind of looking at all of this coming to a head, the new bills, about 90 days from June 30th would be probably my estimate. So, probably sometime in September, the end of September, all these new bills will be implemented and will be, the law. Here's a quick recap of the 4 bills that our firm is monitoring right now. And we'll just go through them one by one. Some only apply to condominiums, or planned communities will indicate which bills apply to which. Okay, so the first one is, and all 4 of these, again, have been passed by both the Senate and the House in Arizona and have been signed by the governor. So 90 days after the legislative session ends, these 4 bills will become the law for condominiums and homeowners associations. The first one is Senate Bill 1039. This talks about meetings and recordings. And basically, this bill requires that if a board records a meeting that is open to members, the board shall keep a copy of the recording for at least 6 months and make the unedited recording available to any member on request. So again, if the board is recording meetings for your association, whether it's on Zoom or on a phone or an audio recording, if your board is doing that in an open session, the board must keep a copy of that recording of that open session meeting for at least 6 months. And if an owner wants to review that, the board is required to make an unedited version of that meeting available to any member on request. And how that would probably work is through the records request law. A member makes a request to see it. The board would have 10 business days to provide that recording to the owner. The next bill is going to be on political signs, and this is Senate Bill 1378. And this bill changes the definition of a political sign to include a sign or a flag. This probably is likely, a result of a lot of the, politics that have been occurring in Arizona and up national level, where many political candidates now are using flags to, support a candidate. And so that was kind of a big question mark previously. Now it's very clear that, political signs are allowed during certain times of the year during an election cycle. And now we also will need to include flag is allowable as well as a political sign. Just an FYI, our firm has been, advising boards, for the past 2 years that if someone's buying a political flag, that they should treat it like a political sign. So I don't think this is going to be a big adjustment for many associations. The next bill only applies to planned communities. So this does not apply to condominiums. And this particular bill is on foreclosures. It's kind of a bad bill, in my opinion. Senate Bill 1494. This is going to amend A.R.S. 33-1807 for the purpose of only allowing a foreclosure of an assessment lien, for a period of 18 months. So if we want to foreclose on somebody and it's in a planned community, one of the following has to occur first. So they have to be, delinquent in the payment of assessments for 1 year, from 1 year to 18 months. So this is a change. So they have to be 18 months behind in the payment of assessments only, or they have to owe $10,000. Now, again, this is just for planned communities. This is not for condominiums. So if we're going to foreclose after this bill becomes effective and it's a planned community, we're going to have to wait until they owe, until they're 18 months delinquent in the payment of their assessments, or they owe $10,000 in assessments only. There's also kind of a technical change in the second sentence of 33-1807A. It changes assessments to any assessment or portion of the assessment. And again, this only applies to planned communities, but that'll be a little bit of a change. And again, I think it's pretty high. That 10,000 is pretty high. I'm okay with the 18 months, but the $10,000 owing $10,000, I think that's a little excessive. So it's or. So if the homeowner is delinquent 18 months in assessments, or they owe $10,000, they will, that's the, benchmark for us to be able to foreclose in a planned community once this law becomes effective. Okay, the last law that we're going to be talking about, it applies to condominiums only. And this is House Bill 2322. This talks about commercial structures and residential structures. This bill addresses assessments on commercial versus residential structures in a condominium. Also included this bill are definitions of a commercial structure, common expense, and residential structure. And again, it applies only to condominiums, kind of just technical corrections in terms of, how things are defined in a condominium. Our office is going to be sharing with you now in the chat on Zoom and in the comment section on Facebook Live our full summary of the pending bills in the Arizona legislature to date. So with all these updates of these 4 bills that have been signed by our governor. This updated summary is also on the homepage of our firm's website at mulcahylawfirm.com. Now, probably in the next 2 weeks, we are going to be notifying everybody that the legislature is closed for this year, for this session. We're a seasonal legislature, so it likely, once the budget negotiations are concluded and the budget is passed, the legislature will close for 2025. And when that occurs, then we'll put out our final legislative summary. Because there's no first Friday due to the 4th of July holiday, we'll be talking more about the bills that have passed again in our July Neighborhood Services Virtual HOA Academy. So stay tuned. We'll also be putting out information on the homepage of our website. And if you have subscribed to receive our Mulcahy memos, we'll be pushing information out on that as soon as the legislature closes. So if you're not on our mailing list and want to be, please email info@mulcahylawfirm.com, and we'll make sure that you are added to our email distribution list on important developments in Arizona HOA and condominium law. Okay, another quick update. We received, I think it was last week, an email from the ACC about some changes that they're going to be making. So ACC stands for the Arizona Corporation Commission. Every HOA and condo in Arizona should be incorporated as a nonprofit corporation or the like. And every year you have to file an annual report with the ACC to keep your corporate status. Why is it important to keep your corporate status? Because you want to have that corporate shield around the association to limit the liability of the individual members in the association. So, breaking news. The ACC announced a new business filing policy which went into effect yesterday on Monday, June 16th. So this is just going to make some changes in when you file your annual report every year. And so there are 4 new policies that have been implemented by the ACC and its corporations division. They believe it's going to prevent unauthorized filings and deter business fraud while also maintaining streamlined customer experiences. In adopting these new policies, according to the ACC, they're attempting to strike a balance between protecting the interests of business owners while avoiding an overly burdensome compliance process. And here are the 4 new policies that you're going to be doing as you are filing your annual report. Some of you, your management company may take care of this, or if you're self-managed, maybe you as a board member are taking care of this. So here are the changes to when you do your annual report. So on policy 1 is you're going to need 2 forms of ID when filing. Doesn't this kind of sound a little bit like the Corporate Transparency Act? It's sounding to me like maybe they're trying to adopt something similar to that, even though we all know the Corporate Transparency Act, is not something that we need to comply with right now, probably never in the future. But anyways, so if you're filing your annual report in Arizona, if you're filing on behalf of a business, individual filers will now be required to present 2 forms of identification. So you need 1 primary form and 1 secondary form, or 2 primary forms. So what are some acceptable primary forms? Like a driver's license that's state issued, photo ID state issued, real ID, passport or passport card, permanent resident card, employment authorization document with photos, U.S. military ID, or a tribal ID. So you can have 1 primary, and then you have to have a secondary one, which would be like a W-2, a birth certificate, a voter registration card, fingerprint clearance card, or health insurance card, or pay stubs. So you need to have 2 forms of ID. It'd be 2 primary forms or a, primary form and a secondary form. Truly, I think most people are going to just do the driver's license or the real ID is pretty much what everybody has now because of many of the changes on, traveling by planes. And then maybe a birth certificate or, a W-2 if people are comfortable, sharing that with, the ACC or a pay stub. I'm pretty confident people are not going to want to do that. It really doesn't give us a lot of direction too. It just says when filing on behalf of a business. So does that mean that me as an attorney that files it on behalf of your association, I can just give my IDs? Or does it mean that we have to get this from a board member? As we start filing these, we're going to determine that. I'm guessing it's probably going to be on behalf of a board member. Also, a different procedure is going to apply for verifying the identity of any service company filers and law firm runners. The effective date for the policy is in-person filings are going to be June 16th. Online, fax, and mail filings are going to be implemented in conjunction with the ACC's new online filing system scheduled to launch later this year. So I'm not sure how they're going to handle this. We just have to, trial and error. We'll be talking about this as we start filing them on behalf of clients in the month of June. So stay tuned. We'll definitely be talking about this again in our July Neighborhood Services class that we'll be teaching, HOA Academy class. Okay, the second change with the ACC is the signing authority form for LLCs. Now, most of our clients aren't LLCs, so I'm not going to spend a big deal on this, but there is a option to submit a signing authority form to help ensure that only properly authorized persons can sign on behalf of the LLC. And then there's also an attestation, this is the third policy, an attestation of existence for LLCs. Again, most of our clients are not LLCs, so I'm not going to go into detail on that. And then the fourth policy change by the ACC is that filers may use their own annual report and certificate of disclosure form. So as an option, the corporation will now be allowed to submit their own self-drafted annual report and certificate of disclosure forms, but only if such forms satisfy all of the statutory requirements and are submitted along with the ACC's guidance worksheet. And again, the purpose of the guidance worksheet is to ensure that any self-drafted annual report and/or certificate of disclosure forms comply with all statutory requirements. The ACC will reject any self-drafted annual report or certificate of disclosure forms that are submitted without the guidance worksheet. And of course, all filers may continue to utilize the annual report and certificate of disclosure forms that are provided by the ACC, which honestly, I would just use those. I think they're very easy to use, and I can't really see why we would go around and create a new form for that, but some people may want to do that. Make sure if you do that, that you follow the guidance worksheet that the ACC has put out there. As always, as you're filing your annual reports, or if there's management companies that are filing annual reports on behalf of associations, please feel free to reach out to us. This is going to be a trial and error process for associations, and we'll just have to see how this new system is going to work. I think really the biggest change with the filing of the annual report is that you're going to have to, file some forms of identification and proof that you are, presenting something on behalf of the association, and you're going to provide identification to do that. Okay, before we hop into our main presentation for today, we want to go back to our poll that was at the beginning of the class. And I just want to say I'm so happy to see that we have over 150 attendees here today. That is amazing, especially because it's so hot out and a lot of people may be already traveling for the summer. So great to see all of you here on Zoom today. So in terms of which city are represented today, according to the poll, it looks like we have 13% from Chandler, 2% from Glendale, 2% from Goodyear. Mesa is knocking it out of the park today with 34%. Great job. Peoria has 8%, Phoenix 15%, Scottsdale 14%, Surprise 7%, and Tempe 5%. Also, in terms of who is our audience today, we have a lot of board members. We have 66% of you are board members, 22% are homeowners, 8% are managers, and then other is 5%. So We're a little top heavy today on board members, which, considering the topic, I think that's expected. So welcome everybody. Really happy to have you here, and we're going to get right into our main presentation. Today we're going to be talking about amending association documents. The summertime is like a great time to be thinking about, should we update our documents? What are the documents I'm talking about? The most common ones are going to be your CC&Rs, your covenants, conditions, and restrictions, your bylaws, your articles of incorporation. All of these documents, your rules and regulations, all of these documents are, the typical documents that are amended in an association. Generally speaking, we do amendments most often on CC&Rs, and then second, often would be bylaws. Rules probably third. We very rarely do changes to the articles of incorporation just because there's really nothing that meaty in that document. Just as a primer or refresher, typically to amend the bylaws, the CC&Rs, and the articles of incorporation, you need to have approval of the membership. And that membership, will be in the CC&Rs or in the bylaws in the amendment section as to what percentage you need to homeowners to approve to amend it. The rules are typically going to be approved by the board of directors. That's the most common thing. The board just approves them at an open board meeting that's properly noticed, and the notice should indicate that we're going to be voting on these rule changes. And so that's just kind of like a baseline for, okay, we're seeing a lot of amendments during the summer because things slow down, and it's a good time to kind of think about, okay, what are some reasons to amend our CC&Rs, right, or our bylaws? And the most common reasons really that we find are that we want to delete restrictions that are outdated. We want to get rid of ambiguous or unreasonable restrictions that aren't working for your association anymore. Big reason is to comply with the changes in federal, state, and local laws. Also to delete or modify provisions that are inconsistent with how things are being managed at your association. To get rid of that developer language that is, outdated. Your developer's been gone for 25 years. You don't want that language in there anymore. So that's another common reason. And also to correct provisions that conflict with other documents. So if your CC&Rs say you're supposed to have 5 board members, and your bylaws say 7, and you want to have 7, you're going to need to amend your CC&Rs to change that so it's consistent with what your bylaws say. Also, sometimes we have language in there that may violate the Fair Housing Act, which prohibits associations from discriminating against certain protected classes. The most typical type of language would be maybe discriminating against families with children or discriminating against persons with disabilities, which is broadly defined under state and federal law. So lots of reasons to amend the CC&Rs. A common question that I get is, how often should we do it? About every decade, I would say, would be a mandatory. Most associations are doing it about every 5 to 7 years, though, because there are so many things that need to be updated. And sometimes, we have over 1,000 clients, HOAs and condominiums in Arizona, and some associations have never amended their documents, and they were done, created in like 2000 or 2006. We've also seen some associations in the 80s that haven't amended their documents. So if you're one of those associations that's listening in today, it's time. You need to update your documents to bring them consistent with, year 2025. We have a little formula or plan that we'd like to share with you in this presentation today that will help your association be successful in amending your CC&Rs and your bylaws or whatever document that requires a homeowner vote. And so we call it like a 5-step plan for amending associations documents. And why did we create this plan? Because we think it's really important to have a roadmap for associations. Amending CC&Rs is a kind of a daunting process because, you have to come up with the changes, and then you actually have to get buy-in from the homeowners and get their yes vote to a certain percentage in order to get them to pass. And you invest time and money and pay an attorney to help you with this. So you want to make sure you're successful if you're going to, invest that time and money to create amendments. So how do you do that? We have a secret recipe here that we've been using at our firm for many years to help associations pass amendments to their documents. And a common question I get is, well, can we just do one or two of these things? And my suggestion back to you is the recipe calls for 5 steps. Don't skip a step because there's a reason for each step. So let's go through the steps on, how to successfully amend your CC&Rs. Okay, so step 1 is kind of an easy one. It's just determine what is required to amend the document. So every document has an amendment section, and you'll want to go to that section in the document that you're trying to change. So for example, on the CC&Rs, of the declaration of your association, usually it's towards the end of the document, on maybe the last few pages of the document, there'll be a section that talks about amendment, and you'll want to read that provision. Sometimes that provision is worded in a difficult to understand way, and so you may want to get your attorney involved to help you interpret it. But typically, what it will say is something along the lines of, this declaration can be amended after receiving approval of the amendment or amendments by 67% of the lots in the association. Sometimes they have a weird provision in there that talks about it can only be amended during certain time periods, like 90 days before the 10-year renewal of the CC&Rs, and that's really confusing. So you definitely want to get your legal counsel involved to help you interpret that. If you have kind of an unusual amendment provision. But I'd say probably like more likely than not, so like 75% of the time, it's going to be pretty straightforward. You need 90% of the lots or units. You need 75% or 67% of the lots and units to approve the amendment. So step 1, determine what the percentages of owners that you need in order to pass the amendments. Step 2 is going to be the longer step. Okay, this is going to be the step where you review the association's documents and changes, and make changes to whatever changes you want in the document. So how we recommend that you do this is take the document, whatever document you're trying to amend, the CC&Rs or the bylaws, put it in Word format, and have the track changes function, in place on the document. And then just go through the document page by page and start making changes or start making comments. And with the track changes on there, we'll see, what the current language is and then what the proposed language is, because it uses like strike throughs and, different colors in terms of what's new language and what's old language, etc. What I really recommend here is sometimes boards will come to me and they'll already have made changes to the document, and that's okay, but not preferred. What's preferred is that we have, a short meeting to discuss step 1. Okay, you need this percentage to amend the documents. Then you give our firm the document for step 2, and we put it in Word format and we start doing the track changes, and we make the changes ourselves first in terms of what we think are, things that conflict with state law or things that are unclear. And I like to get the first draft myself, because if you give me a draft where you've already made the changes, I may have to undo some of your changes to make it consistent with Arizona law or consistent with your other documents, etc. And so sometimes I have to spend time undoing your work, which costs more. So we really prefer in step 2, if you give us a document, without any changes, you can give us feedback. You can give us, an email saying, these are the things we'd like you to incorporate. Or we'd like you to make sure we're consistent with Arizona and federal law and make any changes you think that need to be made, and we want you to address a rental restriction or whatever. That's fine, but actually just give me, I want the document clean in its current form so I can start fresh. After I make my changes, and typically what our office does is we will go through that document probably 5 or 6 times. The first time is just a quick read through of everything, maybe make some small notes. The second time is going to be a deep dive where we actually slow down and start making the changes using the track changes function. Third time, we're just checking again, on the changes we made, reading through the document one more time. Fourth time, it's, some fine tuning maybe. And then the 5th time is the last read before we give it back to the client. And so in this process, we will give you in step 2 our, proposed amended changes to you in a Word document. They're all redlined. It's very clear what our proposed changes are. We give that document to the board. We ask you to review it. And maybe at that time, we ask to have a meeting after the board's reviewed it, usually on Zoom, have a quick 30, 45, 1-hour meeting to discuss the changes. And really the document at that point should be done, right? Now we've got our changes ready to go. So ideally, what we suggest is you have us make the changes in step 2. We give our changes to the board, they review them, then we have a powwow meeting where we discuss, okay, maybe they want me to add some things or change some things. We make those changes, and then we've got the nice clean document that of proposed changes. Then we go to step 3. And this is the step that everybody wants to skip, but is the step that I ask you please not to skip. Okay, so basically what we do in step 3 is we take the changes that we've made and we show it to the homeowners. And we say, what do you think? How do you feel about these amendments? And so there's a couple different ways we can do it. We can send it out in paper format. We can send out an email, or we can put it on the website and say, here's what we're proposing. We're asking, there's a comment period. Please read the document and give us your comments, and give them kind of like a short leash on the comment period, like maybe 2 weeks or 4 weeks, to give us your comments and feedback on what we're proposing to change. Not very many people will actually do that, just so you know, but the people that take the time to do it, they will be providing really valuable feedback to the board about like hot button things in the document that maybe, potentially could be controversial. They'll be giving us feedback on, if they think that the board's taking too much in terms of power, like maybe we allow the board to do something that we weren't allowing the board to do previously without a vote of the membership. It's just really valuable feedback. And for example, let's say you have an association of like 100 people. You may only get 2 or 3 people that respond. That's normal. And if your association is, 400 or 500, you may only get 5 or 6 people, but that's pretty normal. Just look at the feedback that we get in step 3 from the owners. And then we're going to have to kind of talk about it and make some decisions. And that's where we move to step 4. So step 4 is we look at the feedback from the owners that we received from the draft that we sent to them. Maybe you have a town hall too. That's another thing some associations do. They have a town hall to discuss, here's what we're proposing. What do you think? Step 4, we take that feedback from the owners, and now we develop a plan and a reasonable time frame for approval of the proposed amendment. So we listen to their feedback. If people say, hey, we don't think that's a good idea, like we think giving the board the authority to spend up to $10,000 without, a vote of the membership. Some people in the community may feel that that's too much power. I personally don't, but so we're testing different things, or maybe we're trying to implement a capital improvement fee for new buyers, and maybe we're going to try to pass a capital improvement fee as, $2,500 per new buyer as part of the CC&R amendment. Maybe some people say, whoa, that's like way too much. We think that should be lower. So we take that feedback and we talk about it in step 4, and you talk about it with legal counsel there. Another short Zoom meeting where we powwow and we say, okay, here's the feedback. How do we think we need to act on this so that we get the percentage vote that we need from the owners? So there's a strategy in step 4. And we may, if something's really controversial, but we want to keep it the same and vote on it, even though we receive some negative feedback from the owners, we may separate that out and have that be a separate vote on a ballot for that issue only. And then everything else, for the CC&Rs will be yes or no if you pass, the entire amended CC&Rs. We also come up with a timeline for, how long we should leave the ballots out there. So let's say that we're at step 4 right now for an association and it's June 17th. We've got the holidays coming up and it's summer. And so we may decide as an association that we're going to give a longer time period. Like we may say, okay, we're going to send out the ballot and we're going to give people until December 31st to vote on the amendment, because summers people travel a lot and, we need a lot of, it's hard to get the 67% or whatever your percentage is. Make sure you leave it out there long enough that you're going to be able to get the votes you need. Another little practice pointer suggestion that I would give you is you're going to need a ballot to vote on these amendments, and you'll be writing this ballot in step 4. Your attorney likely will be doing that. Be strategic on the ballot in terms of if you're going to have the ballot due back by December 31st, you may want to have a sentence in there that says that the board can extend it beyond December 31st if they don't have enough votes and they want to extend it to a later date. So that's a smart thing to have on the ballot. And really, it's just mapping out, okay, we're going to make these changes based upon the feedback from the owners. We're looking at the ballot. We're going to decide how the ballot's worded. We're going to have that sentence in there saying that if we don't get the vote by the date we're supposed to return the ballots by, the board can extend it. And just kind of mapping out, you're going to have to mail the ballot to everybody in the association. You're going to map out also like, okay, how's this 6 months going to go while we're getting the ballots back? Typically you get like 30% right away, like the people that just vote right away. And then it's harder to get the rest. It's an incremental basis to get the rest. And so what our firm does when we're helping an association with step 4 is we create a Excel spreadsheet with all the owners' names on it. And we, as owners vote, we, state how they voted and we cross them off the list to contact again. So if an owner votes yes or no, they are no longer in the distribution list to get a reminder to vote. And we generally recommend that a reminder should be sent with a blank ballot so they have it handy. About once every 2 weeks. You may want to do it more frequently depending on your association or less frequently. A lot of associations are using online platforms now. Like there's companies that are out there that run, all the voting for associations and it's all done electronically. That may be something you want to look into for your association, and the company just continues to send reminders, and it's a very effective way to get a quorum and to get a large number of people to vote. So all of this is kind of decided in step 4. It's kind of like the strategy on, okay, the ins and outs of the ballot and how long it's going to be out there and what we're going to do to follow up with people if they haven't voted. Hopefully at the end of step 4, we have received the requisite number of ballots that we need to have it pass. And now we're going to go into step 5. Step 5 is finalizing and recording the CC&Rs. Once the CC&Rs have been approved as specified, percentage specified in the documents, the CC&R amendments must be placed into final format by your attorney and recorded at the county recorder's office within 30 days of obtaining, the vote that you needed, the percentage that you needed in order for that amendment to be valid and enforceable. Bylaws and rules, if you're amending those are not recorded anywhere or sent to the state. Bylaws and rules are just placed in the association's file, but you do need to create an amendment to the bylaws or amended and stated bylaws and, keep it with the association's record. Same thing with the rules. If it's voted on at a board meeting, you want to have the minutes reflect that, and those will be kept with the association's records. Do not forget at this stage, tell the homeowners, hey, it passed, hooray, thank you for your help. And provide them with the final recorded document so that they can see the final recorded document. If it's a CC&Rs, or provide them with a copy of the bylaws as recorded, or as amended, and it has been placed in the association's records or the rules. So you want to give the homeowners the information, then put it on the website for the association. All of this can be done by email or, send an email saying, hey, they're passed. All the new documents are on the association's website if you want to see them. Also, do not forget to change, what documents you're providing to prospective buyers as part of the disclosure package so that you're providing the correct amended documents to new buyers as their disclosure package is being sent to them. Quick case that I want to talk about that's kind of an important case for Arizona is the Kalway versus Calabria ranch. So anytime we're mentioning an amendment to CC&Rs, amendment to CC&R process, a lot of times clients will say to me, well, what about the Kalway case? Doesn't that tell us that we can't do amendments anymore? And so I want to talk about that because that's an important case in Arizona law. Just first things first, I don't think it has changed that much how we handle amendments for our clients. Is this case not a good case for our practice area? Representing HOAs and condominiums, it's not a good case. I'll be the first person to say that. But, it's going to be amended, in my opinion, in the next 5 years, hopefully. There are some cases that are working their way through the Arizona Court of Appeals that may fix some of the problems with this case. It's a case we need to be aware of, but it's very manageable, and we haven't had any trouble, navigating around the ruling in this case. So let's talk a little bit about the case. So the Supreme Court of Arizona made a ruling, maybe 2 years ago, about an association's authority to amend CC&Rs. In Kalway versus Calabria Ranch, the Arizona Supreme Court placed restrictions on a community association's ability to create new affirmative obligations to the CC&Rs via amendment without getting unanimous consent of the owners. The primary issue in Kalway was whether the original CC&Rs provided adequate notice to the owners of potential future amendments. It did not. If it did not, such an amendment would require unanimous approval of the members. And the Supreme Court, kind of like a little blurb from the ruling, said, that the restriction itself does not have to necessarily give notice of the particular details of a future amendment. That would rarely happen. Instead, it must give notice that a restrictive or affirmative covenant exists, and that covenant can be amended to refine it, correct an error, fill a gap, or change it in a particular way. And so really some things to think about when we're doing amendments is that the original declaration must give sufficient notice of the possibility of a future amendment. That is, amendments must be reasonable and foreseeable. So Calabria versus Kalway, or Kalway versus Calabria Ranch, it's confusing. So let me just give you the bottom line on it. So when we're doing amendments to CC&Rs, yes, of course, I'm thinking about the Kalway case. I'm thinking about, is this amendment reasonable? Is it easy to understand? And is it foreseeable that this amendment would be, implemented? And, there's some gray areas on this law. And so like a controversial amendment, let's just get it on the table, is a amendment to the CC&Rs to prohibit rentals, let's say. Let's say that you have nothing in your documents that prohibits rentals right now, and you want to do an all-out ban on the ability to rent, anything in your association. So no rentals would be allowed. So you want to go from no restrictions on rentals to no more rentals. Okay, that's going to be really tough to do under the Kalway case because, owners bought with the expectation that they would be able to rent, and it's not foreseeable that that section was going to be amended. And so you probably would need 100% to do a total ban on rentals. Now, one pivot on that would be that you could, pass an amendment that would say no rentals on any future properties, future owners that buy a property in an association after the date this amendment is recorded. I don't think you need 100% approval to do that. So basically, you're grandfathering all the current owners, and then anybody who's buying in the association after the CC&Rs are recorded on this would apply to. So there's ways around Kalway versus Calabria Ranch. I mean, if you want to, let's say you have an amendment section, so you have a section in your CC&Rs that says minimum 30 days rental, and you want to increase that to a minimum of 90 days rental. We can strategize about how we want to handle that in an association. We may have to grandfather some owners that might be currently doing that. We may not have to. We just have to talk it through and determine how many rentals do you have right now? How likely is the challenge if somebody, is going to challenge this? You may have to grandfather them. So the bottom line is Kalway is not a good case for our industry, but we have adapted, and truly it has not really changed how we have handled amendments or the number of amendments in our firm. So it's on our minds, but it doesn't stop the process. Let's put it like that. And so just keep that in your back pocket as we're navigating this 5-step plan, that this case does exist, because if you're trying to do something, I'm sure you'll have a homeowner that'll say, You can't do that without 100% approval under, the Kalway case. And you can reflect back on this class and just be like, oh, well, there are pivots that can comply with Kalway that, would be okay as an amendment. So definitely want to be talking with your legal counsel on all of this because you want to make sure you're making good choices so your association doesn't get sued for any amendment that they do. Okay, let's talk a little bit about what are the statutory requirements in Arizona for CC&R amendments. So we talked a little bit about our 5-step plan, right? I just want to kind of go over there are some statutory requirements that you have to follow when doing amendments to CC&R. So I just want them on the checklist of things that you might need. And we're going to be sharing with you, if we haven't already, this 5-step plan cheat sheet that we've done on amending CC&Rs. And it will also address many of these statutory requirements as part of the 5-step plan. Okay, so a couple things to think about for a planned community. So requirements for, amending CC&Rs. You want to look at A.R.S, Arizona Revised Statutes 33-1817A. And it just says, except during declarant control, the following applies to amendments to declaration. It says the declaration may be amended by the association, if any, or if there's no association or the board, the owners of the property that is subject to the declaration by the affirmative vote or written consent of the number of owners, of eligible owners, voters specified in the declaration. So basically what that means is look to the declaration for the percentage you need to amend the documents. The second part of this Arizona law pertaining to planned communities is an amendment to a declaration may apply to fewer than all of the lots or less than all of the property that is bound by the declaration. And an amendment is deemed to conform to the general design and plan of the community if both of the following apply. The amendment receives the affirmative vote or written consent of the number of owners or eligible voters specified in the declaration. So you need the percentage, and the amendment may receive the affirmative vote or written consent of all the owners of the lots or property to which the amendment applies. So where this could kind of come into play is, let's say that you want to pass an amendment that applies only to like certain owners, like maybe you have lakes in your community, and only certain owners have lakefront properties. Other owners do not have lakefront properties. And you want to pass something that says owners of lakefront properties must, maintain both sides of their fencing or walls. And the reason why you might want to do that is because, hey, it's hard to get there because it's right on the water, right? You need to boat practically to maintain the wall. If that's not already in your documents and you're trying to pass an amendment that applies only to a special group of members, not all the members, you're going to have to get the regular vote that you need, percentage that you need in the CC&Rs to amend the documents. Plus, you're going to need to get the affirmative vote or written consent of all the owners of the lots of the property to which the amendment applies. So all those lakeside owners would have to unanimously agree, to that change, which might be difficult to get. Another portion of the Planned Communities Act that you need to be aware of on amendments to CC&Rs is within 30 days after the adoption of the amendment, the association, or if there's no association or board and owner, can prepare, execute, and record a written instrument setting forth the amendment. So we already talked about that a little bit in step 5, in that once you get that percentage of owners that you need to amend the documents, the clock starts ticking. You have 30 days to get that amendment recorded with the recorder's office. You don't want to wait to the last minute, because you're going to need the signatures of the president and the secretary, and they're going to need to be notarized signatures in order to have that amendment be recorded. So your attorney should be handling all of this for you, writing up the final amendment language and, sending it to the president and the secretary to get their, signatures in front of a notary public, and then recording it with the recorder's office and the county where your association resides. There also are some special condo requirements, very similar to the planned community requirements. But a couple notable things would be there's a restriction in that you can't go any lower than 67% of the owners. To amend your CC&Rs. So if your CC&Rs, if you're a condo and your CC&Rs say, you need 51% of the owners to approve the amendment, or 51% of the units to approve the amendment. State law is going to trump that. You can't go any lower than 67% of the units in the association. So that's kind of an important thing. You're looking at your documents, and if your documents are wrong and don't comply with state law, you got to continue to follow state law, which should be 67%. It could be higher than 67% if your documents say that, but can't be any lower than 67%. Really, you have to record the amendment, within 30 days after it passing. Really it's kind of similar to the same things that we talked about with the Planned Communities Act. One thing that you may also want to know is if you want to challenge any amendment that's done in a condominium, there's only a 1-year period you can challenge it after the amendment is recorded, which is kind of unusual. That only applies to condos. In a planned community, it's likely just going to be the statute of limitations for breach of contract, which would be 6 years. Okay, so that's just kind of a really good summary of our special recipe to amend CC&Rs, just the 5-step plan. It works. It's worked for many of our clients. If you're going to invest the money to do an amendment and invest the time to do an amendment to your documents, you definitely want to follow that 5-step plan. In our cheat sheet, if you want to go back and look at it as you're navigating the 5-step plan as an association, our cheat sheet is on our website. It's called It's called the 5-step plan for amending association documents. And you can find it on our website at mulcahylawfirm.com. Okay, let's talk a little bit about rental restrictions, because that seems to be really a big issue in associations right now. Like, I get a lot of calls on short-term rentals, that Airbnbs and VRBOs are wreaking havoc in an association, and what can we do about it, etc. So let's just kind of talk about what's the current state of our industry, right? Since all of these companies have come in and are doing nightly transient rentals in associations throughout the valley, it's kind of really changed how things operate in many associations, right? Because prior to a change in the law, maybe now 9 or 10 years ago, there was the city or the town that you lived in regulated short-term rentals, and they did that through ordinances. And they had zoning that hotels could only be in certain areas that were zoned a certain way. And if you lived in a planned community or a condo, they weren't zoned to have nightly rentals. And so typically it was minimum 30-day rentals. Well, there was a law passed about 9 years ago that took away the ability of the city to regulate those short-term rentals through zoning. And it said basically, if an association wants to implement short-term rentals, it needs to be in the documents. And they can amend their documents to put that in there. And so things really shifted when that law changed, because it used to be that, hey, the city just kind of took care of this for us. Like, we weren't going to have nightly rentals in our association because the city had zoning that, if you weren't zoned as a hotel, transient housing, you couldn't do it. And if you did do it, the city would come in and, issue violations, and it was something that they took very seriously. Now we're kind of in a different phase where if we want rental restrictions, it really does need to be in our CC&Rs. So, and this in conjunction with, the Waste Management Open and, Super Bowls that we posted, and Final Fours and NCAA first and second rounds, etc. And just the great climate in Arizona, the wonderful weather, and, people migrating to Arizona from the cold states or migrating to Arizona for more opportunities in business. We're starting to see a dramatic increase in the number of rental properties and associations. And unfortunately, sometimes these tenants aren't following, the association's documents. And it becomes very frustrating for boards because, they have rental properties that are creating a lot of problems and creating an issue where it's taking almost all of their time, and they can't get anything else done because they're dealing with a lot of these problems. So, if you're one of those associations, we just want to give you some tips today on what your rights are. And it could be for a long-term renter too. It doesn't have to be a short-term renter. It could be, a long-term renter creating issues. And so we just want to give you a quick 411 on, what does the law say in Arizona about rentals in HOAs and condominiums, and how can we pass an amendment, etc. So remember, if you're going to do an amendment to the CC&Rs to implement some sort of a rental restriction, definitely want to be talking to your attorney, especially because of the Kalway case that we talked about, and to come up with a plan with a legal way to do it, so that you're not going to be sued. And so you definitely are going to have a strategy call with your attorney to talk about, this is what we want to do. How can we implement this rental restriction, in light of the Kalway case and in light of what our documents say? So you're likely going to need membership approval. You may want to consider having a grandfather clause, which we talked about a little bit. So when we gave the example of totally banning rentals in an association that is currently allowing them, you may need to do a phased approach, which means that you're going to grandfather all the current owners, and any new owner who moves in, they will have, notice that, hey, this is a no rental community. And that's one way to get it passed. Another thing that's important is if you have a problem tenant in the association, and you're navigating that they're bringing glass to the pool, or they're having wild parties, or, they're not following, the CC&Rs and restrictions in your association. Really what I found is that the owner is responsible for the behavior of the tenant, and quickly notifying the owner that, hey, there's a problem here. And, this is a contract. You're responsible for the behavior of your tenant, and fining the owner, because, basically they're renting their property to make money. If you can fine them in an amount that's similar to what they're making in terms of the profit on this, it's going to be a very effective tool for them to get renters in that are going to be better behaved, because they don't want to lose their entire profit just because the renter is behaving badly. And what I found is typically a board will come to me as legal counsel, and they'll say, hey, we've got this problem with this renter. And they'll explain to me all the issues. And what we will typically do, and it has been really successful, is we'll create a violation letter to the owner outlining all the problems, attaching the police reports, if there's police reports, pictures, whatever. And then I will send it to the owner, and I will also call the owner at the same time and have a phone call with them. And usually how the phone call starts out is they say, yes, I know you're from the association. This board is so picky. They're picking on my tenant. My tenant is just trying to live there in peace, and, the neighbors are, making up stuff, whatever. And then I started to talk to them a little bit about, well, were you aware that, the SWAT team came in 2 weeks ago, or the DEA, or, the police have been called 8 times in the past week. And here's the police report, and here's pictures of what they're doing, and here's a recording of, the wild party, how loud it was. And usually there's a shift with the owner when I'm on the phone with them, and they start shifting to understanding, like, uh-oh, this is a problem. And then I tell them, listen, this is just going to get expensive for you as the owner, and you're responsible for the behavior of the tenant. So, we're going to be fining you. We may possibly file a superior court action and a lawsuit against you, and seek an injunction compelling you to, maintain control with your property and make sure that your tenant is abiding by the documents. And that's going to, result in at least $10,000 in legal fees, which will be your responsibility. And you just kind of pile on, like, okay, here's the problem. Here's what the problem is going to mean to you in terms of, litigation hassle and cost and fines and expenses and attorney's fees. And the dominoes just start falling, because the owner is going to see it right away. There's liability here. I'm going to owe a bunch of money, and this is going to be a major hassle. And usually the owner either evicts the tenant, or the owner gets the tenant to behave. And so that's a really good strategy if you have a bad tenant right now and the board is just hitting their head against a concrete wall because they can't get it resolved. Getting our firm involved, we contact the owner. We send a very firm demand letter to the owner, and then we pick up the phone and talk to them about it. It's a good strategy that works. I can't think of one time where we didn't have that be successful. Also, if you, let's see, anything else on rental properties? Okay, a couple things that I want to mention that you need to be aware of if you are an association that has, owners that are renting their property. Number one, landlords must register their property with the county, so that you are aware of that. That's on our cheat sheet. You'll see it on page 2 of our Amending CC&Rs 5-step plan and implementing rental restrictions. Landlords must register their rental properties with, the county. If you're in Maricopa County, you can see if a property is registered as a rental by going to the Maricopa County Assessor's Office or the Assessor's Office in any county that you're currently living in. And it will, when you pull up the address of the property, it'll indicate if it's owner occupied or if it's a rental. If you find as a board that the owner says it's owner occupied and it's not, you can file a complaint with the county and they will investigate it because they want that income on the taxes that they would be getting for every rental. So landlords must register their property with the county. Don't forget that. You may want to double check to make sure that your landlords are actually doing that. What are some laws in Arizona when an association is working with a rental property? Like what types of things can we ask for from the landlord? So really important thing to think about. We can ask for the name of the tenant, the adults residing in the property. We can ask for vehicle identification and license plate numbers. We can ask for the length of the tenancy. So is it a year or whatever, 6 months? And if it's a 55 and over community, we can ask for proof that one of the occupants will be age 55 or over. So those are kind of 4 things that we can ask for. We cannot ask for a copy of the lease under Arizona law anymore. They can voluntarily give it to us, but we can't make it mandatory. A couple other things you want to know about, an owner can designate a third party to be their designated agent, and they could designate their tenant to be their designated agent for the property, and the tenant would then be allowed to attend board meetings and talk at the board meetings on behalf of the owner. That doesn't mean the tenant can vote. They cannot vote. Even if they have a power of attorney, they cannot vote. Only the record owner can vote. But it does allow them to attend and participate in terms of being able to talk on behalf of the owner at a board meeting or at an annual meeting. Let's see, what else is important here? We can charge the landlord for a change in each tenancy. So anytime there's a change in, the property and a new tenant comes in, we can charge $25 to the landlord after, requesting information from the landlord. So we say, can you please provide us with the 3 categories of information that I just talked about: the name of the adult tenants in the property, the vehicle descriptions and license plate, and then how long the tenancy is going to be. And we can tell them at that point, you owe $25 for this tenancy. And if they don't provide that information to you, or they don't provide the $25, we can, and give them 15 days to do that, we can charge an additional fee of $15 for them not complying with doing that. And that's the most we can fine for not complying with that, because it's set up under state law. And I think really that kind of covers it. We have to be really careful. Like, we can't do anything else to limit the tenant's due process rights, etc. We can't ask for a credit report of the tenant or even a copy of the lease, as I talked about previously. One kind of weird thing that I want to mention, and I know we're into a little bit of overtime because it's 12:03, but this is important that I think you need to hear. There's a statute in Arizona that says that the landlord must abate criminal activity in the unit or lot, because any residential property that is regularly used in the commission of a crime is a nuisance. So an owner or landlord must abate criminal activity that's happening in their property. We frequently will put that in a letter if we think that that is happening. And in my career, I've seen one time where a landlord was actually prosecuted by the county because they were like a slumlord, and they were allowing all of the properties that they owned, to have drug activity and drive-by shootings and all kinds of crazy stuff. And the landlord was actually convicted of violating this section and not abating a nuisance. And there were some pretty serious consequences for the landlord. So we always want to keep that in our back pocket. If we're seeing something like that, we want to tell the landlord, hey, under this statute, you can be held criminally liable for the behavior of your tenant if you're not abating the nuisance. We talked a little bit about short-term rentals and how we want to implement short-term rentals. Just a friendly reminder, if your association is wanting to implement a rental restriction, we definitely want to get your legal counsel involved and talk about how the Kalway case may affect that and come up with a strategy to do that. Today we had 174 attendees at peak, plus anybody who joined us on Facebook Live. So amazing turnout today. Thank you very much for being here. Want to just mention a few procedural things before we sign off. We are not having First Fridays in July due to the 4th of July holiday. So the next virtual live First Friday event will take place on Friday, August 1st. We have a class coming up in July, a neighborhood services class that we teach in conjunction with a number of different cities. And that's going to be on July 15th. It starts at 11 o'clock, just like today. And it's going to be on Zoom and Facebook Live. And we're going to be talking about how to enforce CC&Rs. So lots of questions on this today. So how do we enforce CC&Rs when you live in an HOA or in a condo, and how to best handle lawsuits and fines and violations and rental issues and parking problems and refusals of owners to pay assessments and owners who make changes to their property but never get approval. We're going to cover all of that. We'll also have a Q&A session at the end, so make sure to bring your questions on any enforcement issues or any other issues. So that's it for today. Just want to say thank you again to everybody for joining us. Have a safe, happy, and healthy 4th of July. And I will look forward to logging back on July 15th for our next neighborhood services class with you. Take care, everybody, and have a great rest of the week.